Let me introduce our regulatory panel. Right next to me is Spencer Doak. Spencer is the Director for BSA AML Policy at the OCC. Next to Spencer is Sarah Green, Senior Director, Enforcement and BSA Policy for FINRA. Then Christine Rings joining us from Canada, the Managing Director of AML and Compliance Division at OSFI. Andrea Sharon, Associate Director of the Policy Division at FinCEN. The non-regulator but former regulator is Rick Small, the Executive Vice President, Director of Financial Crimes Program at BB&T. And last but not least, Suzanne Williams, the Deputy Associate Director of Bank Supervision and Reg at the Fed. Just one quick comment. The FDIC wasn't able to attend a number of scheduling conflicts. They obviously have participated in the past and we know will in the future, but I did want to mention to everybody that that's the reason you don't see a representative from the FDIC today. What I want to do, we have a number of topics we're going to touch on. I'd like to start off, though, with our first polling question. Our first polling question is something that we'll be covering throughout the conference. How close are you to CDD implementation? Obviously, the regulation is final. You have to have it up and running by May of 2018. So here are the options. We're finished. It's great. You're not going to learn anything this week, then if you're done.
I would text, but I don't.
The work streams have begun, but the project is ongoing. Very early stages. And last but not least, haven't started. Now, on all of these, it's anonymous, obviously. It's just a temperature check in time. I will tell you, I did a conference last week in Missouri of small banks. Basically, the asset size was about 150, 180 million, so really small institutions. And it was a panel discussion with some bank reps. None of those bankers had started yet, and they said in part because they had come to that conference to share information on how they could learn from each other. We'll talk a little bit later about something that Rick and I and Kieran put together on CDD as we go through the various topics. And he's got a session here. We got a number of sessions here. But it was definitely instructive to see that a number of the smaller banks were sort of waiting. Now again, that's just one region and about 100 bankers, that sort of thing. But I think it's interesting because we all recognize the importance of it and trying to get it right. Okay, number of big topics we're going to cover, but first I'm going to go to everybody and give them a chance for some opening comments, but just to sort of set expectations and the stage, and some of the comments, they may reference some of these topics. We want to talk a bit about priorities from all the agencies. Obviously, there's an ongoing update of the FFIEC manual. A number of the folks here are involved in, or their designates are. The CDD thing, as we just talked about. SARS and STRs, we're doing sessions on that, but the folks here have some thoughts. Cross-border challenges, just kind of from a large standpoint, if you're a multinational institution, what are maybe some of the practical things you might be thinking about? Risk ranking is something we're all doing in terms of risk assessment. We'll talk a little bit about that. We obviously heard from Fred Kaplan on cyber. There'll be sessions on throughout the conference in the cyber track, but I'd like to get some initial thoughts from the folks here about cybersecurity from an AML perspective, and then issues regarding data integrity. So these are just some, and there's some topics on the next slide. But let me start with Suzanne and give everybody an opportunity to just give us a couple of opening thoughts, and then we'll dive into some of these topics. Suzanne?
Thanks, John, and thanks to ACAMS for inviting me to share some thoughts with you this year. And before we get started on the substance of the discussion, I'd just like to add that I've been on panels with John for more than 12 years, both at ACAMS and in his prior role at the ABA. And, we've always known we could rely on John for his spirit of collaboration and unfailing focus on doing the right thing and getting to productive outcomes. So I just wanted to mention that in light of the changes that you were referencing. So to the substance, I just wanted to share some common MRAs and MRIAs that we've identified in our examination and supervision. Overall, we're not seeing huge changes in volume or trend. Routinely, the number one category is internal controls. But what I thought I'd do is highlight, just to get us started, a few that have some implications for our customer due diligence discussion that we'll be focusing on more in general. So, as you know, foreign correspondent banking has an explicit CDD requirement within the rule, so we have some experience in that context, but also domestically and for other customers, we have experience with CDD based on our supervisory expectations that are in the FFIC manual and the linkage to the SAR requirements. So some problems that we've identified are that the customer risk rating methodology or the profile does not facilitate a reasonable understanding of the customer's AML risk. Perhaps the risk rating is based only on one factor, such as country or one factor, and it's unclear how that's linked to their transactions or the customer's rating. So you could have two customers that have a similar type, similar rating, but if their transactions, both in type and volume, are significantly different, that's something that we would expect would probably be reflected in the risk rating. We've also identified and criticized situations where the customer risk rating or the risk profile is not driving greater scrutiny. So as is illustrated in an appendix to the manual and is described in the text, the customer risk rating is tied to the system of internal controls, and in particular the suspicious activity monitoring. So how are the CDD account opening procedures, as well as how much information you're collecting, how frequently is it updated, how is that informing your review or monitoring for suspicious activity, understanding the purpose of account and what's expected. We've occasionally seen processes in CDD poorly documented or delayed, and also insufficient MIS or IT systems that are necessary to support some of this data or risk rating. So, the bottom line is if a customer is rated high risk or higher risk, that should mean something in terms of the information you collect, how you monitor them, your overall policies and procedures. So those are just a few things from our current sort of experience with MRAs that I think are going to be relevant to our later discussion.
Great, thanks, Suzanne. I wonder, can we bring the poll back up? I want to go to Rick here. As we're doing that, Rick, sort of opening thoughts. Let's see here. In terms of the response, most have said the work streams have begun, but the project's ongoing, which obviously is positive, and that's a nice outcome. But Rick, I alluded to the fact that we worked together on an event that we did in DC in June with just financial institutions on CDD, and obviously the outputs of that have been publicized and put on our website. Maybe mention that quickly, and then anything else you want to, in terms of opening comments.
Sure. So thanks, John. So we got about 125 participants together back a couple months ago in Washington, and the idea was to get institutions in a room where they could have unfettered, open discussions about questions, concern, issues, and talk about how they're going about looking at implementation of the CDD. We did spend most of our time talking about the beneficial ownership section of the CDD rule, but we talked about some of the others as well. I took away from that folks are approaching this in very different ways. All of those ways are good. I do think that will be a challenge, and hopeful that we'll talk about that a little bit more without a lot of direction yet or guidance from, for example, the FFIC exam manual in terms of what expectations are. We can only rely on what the rule says, what the notes say about that, and how we are interpreting that, which we are doing. So the session in Washington, I think, provided a lot of good understanding that we weren't operating in a vacuum. A lot of us were thinking about similar issues and how to go about doing that, and again with some different approaches. To John's point, we actually have two sessions scheduled tomorrow, one in the morning, one in the afternoon, where we're going to try and repeat what we did in Washington to give you all an opportunity to sit at tables with other colleagues of yours and talk about where you're at in the implementation. Any concerns, issues, comments, how your approaches are. Apologies to my colleagues, but we're going to only allow financial institutions in the room to do that, so that, again, you can have an open, unfettered, feel comfortable having that discussion. And as if you've seen what's up on the ACAM's website about the outcomes from the June meeting, I think you'll find that very instructive and very helpful. And if nothing else, to get a comfort level that your colleagues are thinking about it the same way you are.
Great. Thanks, Rick. Andrea.
Well, first, I think that is such a great thing that you're doing to bring institutions together to talk about their experiences in implementation, because there are some experiences that they will have that interaction with each other is almost better in a lot of ways than it is with regulators. But that doesn't mean we don't have an important role. And to that end, I will say, we issued FAQs initially, basic FAQs to help folks understand the basic elements of the CDD rule and beneficial ownership as it relates to that. And you leave a little time to go by so that we can gather what the experiences are. And we do anticipate putting out some additional guidance in some format, maybe FAQs, that will address some of the really, putting frequently in the frequently asked questions that have come to us. So I'll be very interested in some of the outcomes even from this meeting. And every year, John asks, we're in Vegas. What's happening with this industry? So I thought I would just spend 1 second talking about that. And, I want to say for the casino industry, there's been such an amazing improvement or growth in aspects of what the casino industry is doing. So, for example, in 2013, there were maybe 27,000 SARS that were filed. Here we are just 3 years later. We've, had interactions with the industry talking about expectations, and what we've seen is more than doubling the amount of SARS that are being filed in this industry to 57,000 in 2016. And we're saying, 2017 is on track for some, good information as well. I think if you look back at some of our recent enforcement actions, and of course we try to detail, all of the rationales behind what the violations are and what was right and what was wrong. I think you'll see, a couple of things. There's, for those institutions that did have enforcement actions initiated, we saw sort of this, need to better adopt policies and procedures that are really appropriately risk-based, and that are reasonably designed to really assure and monitor compliance, because the failure to do that in the first step can snowball into all these other BSA violations. And, one of the things we've seen gets back to things that we talk about every year involving culture of compliance. For example, in one case, the management consistently ignored the BSA officer in being said, we have to file this, we should look at that, what about the CTRs, what about the other thing? And as a result, they didn't, they had significant repeated failings in their reporting obligations. They had things that they were supposed to do that they had written down, but then they never did it. For example, they had a SAR review team. You're not obligated to have one, but they did have one, but they never met, and people were on it that didn't even know they were on it, right? So you have to really mean what you're doing. And then, in some cases, we had, issues around knowing who your customer is. We had, in one case, there was, over a 20-month period, about 80% of the SARS filed had at least, if not more, one unknown customer. And the bottom line is, if you don't know who's coming into game, it's difficult to comply with your other obligations. And for one other example, they had didn't have a lot of information, an unknown customer. There were 15 SARS filed on that specific customer, and that customer also refused to provide ID on many occasions, but they still allowed that customer to gamble. So those are the kinds of things you want to, kind of pay attention to. And then finally, when you are filing your SARs and you're thinking about SAR quality, some of the SARs they would file, but they wouldn't say, oh, and by the way, this is not the first time we're filing a SAR on somebody. We filed SARs on those folks in the past. And also, looking at all of the information to figure out the patterns of suspicious activity was lacking in some of those. So those are some of the areas I think that could use better attention in some of the work doing in this industry.
Right. Thank you. Christine, you've been kind enough to participate in both our Hollywood and our Vegas conferences, and obviously part of the reason we want you to participate is not just simply talking about what's going on in Canada, but there are parallels, and you do a lot of international work as well. So what are you seeing in terms of institutional response to AML, and then what other issues are you folks currently working on?
Sure. Thanks, John, and thank you to ACAMS for having me here today. Many of the issues that Suzanne mentioned, very similar to the work the issues that we're seeing in Canada. From OSFI's perspective, we are the prudential regulator. My division focuses solely on AML. We do ongoing assessments, monitoring work, follow-up work. And there's several areas that we continue to see, and that seem to be the same themes everywhere, just showing how complex these issues are. We continue to see challenges in inherent risk assessments. It is a key foundational document for a successful AML program, so it's always a focus of the work that we do. We continue to see challenges in both development of the methodology and the actual application. Development issues can range from a methodology that focuses on net risk, where they consider controls rather than just focusing on inherent risk, missing prescribed legislative factors, which is, unfortunately, it's pretty basic, but we do still see that. Lack of a rationale for client risk ratings, and then things like failure just to update this and see it as an evergreen document. We see issues with application in terms of consistency, particularly where based on structure, some of this is decentralized to the lines of business, and gaps in oversight leading to inconsistencies. Another area of focus for us is with respect to the 3 lines of defense model. At OSFI, as a prudential regulator, we are very focused on the quality of controls at an organization, not just for AML, but any aspect of risk. And so we spend particular focus on first, second, and third lines of defense. We do continue to see some challenges. With respect to the third line, contributing to this sometimes is lack of AML expertise in the internal audit function, and therefore the focus on the testing is very much on the existence rather than the quality of the controls and the appropriateness of the controls for the AML factor. We also see with second line of defense that this is a continuing evolution, various stages of maturity, where some institutions are still developing a second line of defense model. And from our perspective, OSFI does have an expectation that CAMLOs on an annual basis provide a self-assessment report to senior management and the board. So for us, the second line of defense model enables the CAMLO to be proactive in the testing, assessment of the risks in the program and those gaps, and then be able to be proactive and manage rather than waiting for the third line to come in and speak to those challenges. I just wanted to mention, some things are similar and some things are different between Canada and the US, but ultimately we all seem to face various degrees of regulatory challenges. In the Canadian space, we are, in June of 2017, a regulatory package that was issued in June of 2016 came into force. And we're currently dealing with industry on a few areas of challenge. 2 that I'll mention just briefly today is ongoing monitoring, and the other is everyone's favorite topic of beneficial ownership. Ongoing monitoring in Canada does not envision a trigger event for lower risk customers. And for beneficial ownership, the standard in Canada is, I believe, a higher test than the US, where you do need to obtain as well as confirm. And it's the confirming piece in Canada that is of particular discussion due to lack of public registry and the challenges around obtaining independent information.
Great.
Lots of similarities and a few nuanced differences.
Thanks, Christine. Sarah.
Thanks, John. I may have to step away from this panel early to call my husband and tell him to unplug our toaster, refrigerator, and any other appliances in our house after that keynote address. That was a little scary. But thanks so much for having me, John. And I know there are some securities firms in the audience as well as other financial institutions that have securities affiliates. For those of you who don't know, FINRA is a securities regulator. We're really the frontline regulator. The SEC has slightly narrower jurisdiction in the AML space. So I'm happy to be here and happy to see so many familiar faces in the audience. I know we're going to come back to exam priorities, but I just wanted to mention a few things that are kind of on the horizon for FINRA in terms of guidance this year. It's so nice to have the opportunity to come to this conference and learn about things, but obviously not everybody can come to these, and I think guidance is another way to kind of get the word out about some things. So many of you may know that we have a list of red flags. We originally came out with our kind of AML red flags in a notice to members in 2002, and we've refreshed them, I think, once since then, but let's just suffice it to say that they need refreshing. So we do hope to come out with revised AML red flags sometime this year. Similarly, we published at the beginning of the year, which I'll talk about when we come back to it, our regulatory priorities, some of which are AML. And this year we're doing something a little bit different. We are publishing kind of an update. Before the end of the year, we're going to publish kind of an update on how we're doing on some of those findings that we mentioned in the regulatory priorities letter. So you can keep your eyes open for that. Similarly, the CDD rule, we will probably come out just with some brief, really more of a summary of the rule, maybe for some of our smaller firms who may not be as familiar. But that's another thing to look out for. And finally, just for those of you who don't know, FINRA publishes something called a small firm template. It's an AML, it's kind of a template AML policies and procedures that small firms can use as a start. And let me underline that word start. It is not meant to be, the finish line, right? It's something that you start with and then you customize to your firm and your risks and your products and so forth. But for those of you who don't know about that, that's a helpful resource, particularly for smaller institutions. You might want to check that out also. It's all available on our website and all free and available to anybody.
That's great. That's very, very helpful. Spencer.
Thank you, John. And I wanted to say thanks to ACAMS for the invitation to be here again this year. We have a great turnout again, which I think is excellent. Let me start out by saying that this is a very opportune time to recognize that the vast majority of the banks that the OCC supervises have satisfactory BSA AML compliance programs. That's a great thing. That doesn't mean you can't fine-tune, that doesn't mean you can't do more about it, but that means that the vast majority have in place appropriate programs. I think it's also important to note that, especially given all the things we're hearing, the keynote today and so forth, that bank management should really be viewing their BSA, AML, and counter-financing of terrorism department as an essential cost containment center. Let me say that again, cost containment center, rather than a cost center. If they're not viewing it as a cost containment center, they're missing one of the basic tenets of what you're really doing for the institution. This department, the BSA department, is vital to both the bank's financial integrity and really on a broader level to the national security of the United States. So I think it's very important for you to take that message back. I might be talking here to the choir, so to speak, and that's okay. But I think it's important to take that message back. What I'll do, I know we're going to go into some of these other topics, but let me just briefly touch on a couple of things along the lines of what Suzanne touched on. Some of the areas that we're still seeing in banks that have some issues relate to CDD. They relate to knowing their customer. We're still seeing customer onboarding methodologies that are sometimes inconsistent with existing customer risks. In other words, the customer risk profiles have really outgrown. They've changed due to changes in markets, changes in products, services, etc. And the methodology needs to keep pace with that. I've probably mentioned this one in the past, but we're still seeing some evidence of client risk rating methodologies being used as a checkbox. It's really just an exercise where you're walking through and collecting data. Really, but then the next step should be to use that information to complement everything else you do, including your suspicious activity monitoring system. So I think those are two very important points from an opening standpoint here that relate directly to the CDD rule. Thank you.
Great. Thanks, Spencer. In a few minutes, I'll put up another polling question about corporate culture, because we do want to get your sense of how you think your client or your institution is behaving. Because to Spencer's point, it is the choir in here. We obviously understand the importance of everything we're hearing today, but our folks above us, or we as part of the management team, are our colleagues understanding the same way. So I think that's always pretty important. So I'm going to sort of do a jump ball here and throw out, I think a couple of these you can kind of put together. But when we talk about the priorities of the different agencies, I'd like to hear about that. But also, Suzanne, I'll just throw this one with that, and that's the manual is being updated as we speak. You folks are involved in that. Obviously, people always ask generally what the timelines are. I will just say one thing that I've always been impressed with since you guys have put this together back in 2005 is the outreach that the agencies have done to the private sector and asking for input. So I know in my previous life we were able to do that, and just recently you will actually see this. We'll get this to you by the end of the week. We're working together with the World Bank and nonprofit organizations to come up with suggested potential changes to the manual regarding how to deal with charities and humanitarian groups because of the age-old issue of financial inclusion and access. So we're going to be sending you recommendations, but I know you've also been meeting with all the different trade groups, and you're still doing that. Can you give us both a sense of where that stands and then maybe some of the agency priorities in addition to updating the manual?
Sure. So, a couple things related to that. We understand, given the time frames, that the part of the manual that already exists, actually, that talks about CDD, we need to get that out sooner than the entire manual. So that is our plan. That's what we're working on, is that we're developing that in consultation with all the usual suspects, and we intend to put that out separately, and that would be something we can do in a shorter time frame than the entire manual. So it's been really interesting to look at this existing CDD section in the manual, as well as other parts, because the CDD rule has the 4 components, and 3 of the 4 already exist: CIP, SAR monitoring, and then our CDD supervisory expectations. So distinguishing between our existing expectations and what banks are already doing under the CIP risk-based approach, specifically the risk-based approach to look through your legal entity customers and collect that beneficial ownership information, versus the new provisions of the rule, which are mainly centered on the beneficial ownership piece for legal entity customers. And then the additional challenge is related to actually some of the other things that I think would be good to talk about, is that you have the technical requirements under the beneficial ownership piece, and then you have beneficial ownership as part of one of the 4 elements of a risk-based CDD program. And describing that and clarifying our expectations, and while doing that in a way that is true to, if you look at what's in the preamble to the Federal Register notice for the final rule, it has statements about the rule being a floor, not a ceiling. and that nothing in the final rule is intended to lower, reduce, or limit the due diligence expectations of the federal functional regulators, and that it's anticipated that that the standard in the CDD rule is simply articulating current practices pursuant to existing standards and expectations. So there's current practices, for instance, one that I'd like to highlight, I think it's important to a lot of people, is in the manual, in the CDD section, it says that the understanding about what's usual and expected for a customer can be developed, it doesn't have to be individual to each and every customer. It can be developed, especially in lower risk situations, by the fact that it's a particular type of account, a type of customer. I think the usual example is your low dollar retail checking account, that you don't have to go to each and every one of us and ask what their intended use of that account is. That understanding and even that risk profile can be developed as part of that sort of, understanding of as a group. We intend to maintain that expectation or understanding. So that's really what we've been focusing on now. But having better clarity or defining what we mean by a risk-based CDD program, raises other issues about other sections in the back of the manual, like the NGO charity section, and, you have a mix of different topics and issues in the back. So we have to think through how that all integrates and ties to other pieces.
Spencer, other thoughts?
So yeah, we are all of us are involved in the drafting group, and I think we've made great progress with regard to the CDD section, revisions to that, as well as to the new section on beneficial ownership. I think these will provide clarity to examiners, which is what they're supposed to do, and hopefully the bankers will get some value out of them as well. With regard to building out your program around this and so forth, it's so important, so imperative that you really stop now to think about, based on the polling question, about where you're at on that timeline. Are you on a trajectory to meet the rules implementation date of May of 2018 early, or are you going to be coming in slightly behind? Looking at that and making sure that you have appropriate processes in place and a timeline in place to meet that goal. I think it's also important not only to meet the goal, but also to say, what about testing before it goes live? What do you need to do before you actually get into that, to that finish line and test all the other things around it? We were talking, I think the question was really around NGOs and around building out the manual and so forth, though. That is certainly something that the drafting group is taking into consideration. We are meeting on a regular basis now with outside groups. They include all the industry groups. We're taking information in from all the industry groups and considering exactly, what we can do to update the manual to make it more meaningful based on that feedback. So I think that's very important to us as well as a drafting group.
Andrea, I wanted to ask you, is it safe to say that one of the priorities at FinCEN has been real estate? Obviously, you do the GTOs, but there's also been a lot of pretty strong statements about the clear vulnerabilities in real estate regarding cash purchases. Obviously, if you pick up any newspaper, there's a lot of discussions regarding that. Does that continue to be a priority for FinCEN, and what other priorities are you guys working on?
So I think that, real estate is an important focus. I think you might have seen we just issued a new GTO with our, clarified authority to collect wire information, which we believe will give us, a degree of magnitude of information beyond what we already have that will help us think about, the real estate issue. I think if you look at the unified agenda, real estate is on that. So I think, we just issued also a advisory to the financial industry as well as the real estate industry saying, here's some things that be helpful if you guys look at, and even though you're not, necessarily, in the real estate industry obligated at this stage to file things, suspicious activity reports or give us other information, we're going to ask you to voluntarily do that, which, they can do under the Bank Secrecy Act as it currently exists. So it is something that we are looking at very, very closely, and we'll figure out, what the next step would be. And gathering this information from the GTOs was part of that, was to figure out to what extent, we need to take that next step in the real estate industry. If you remember, the BSA has maybe 26 types of financial institutions, and Congress said go out and cover all of them. And we have focused on, over time, the ones that create the greatest risk that we need to address. And, we did that in real estate and looking at residential mortgage lending, and now we're looking at cash purchases, particularly for high-end real estate, and thinking about those issues. I think as far as other priorities, there's a lot of discussion, whether it's through the Agrippa process, whether it's things that come up in BSAG or industry white papers that have come up, that really are saying, let's think about ways that we can improve regulations to increase effectiveness, reduce burden, not compromise financial inclusion. And I think that's something that we are looking at very, very closely. I know it's something that our Undersecretary is committed to in thinking about. So I think those kinds of things are going to be the kinds of things that we are thinking about and going forward. And of course, as the CDD rule comes closer to its implementation, we want to make sure that industry has the information it needs to successfully implement their program. And so we'll be doing some more of, as I mentioned earlier, guidance around some of those issues. So those are, it's very broad, but yes, those are some of the things that we are thinking about for the upcoming year.
Sarah, you mentioned the reg priorities. It's up on your website. I think you also talked about data integrity, if I'm not mistaken.
We did, yeah.
Can you talk a bit about that?
So that was certainly one of our priorities this year. We looked at, we encouraged firms to look at data integrity in a couple different manners. First of all, what are the, and this is obviously for kind of any systems you have, thinking mainly about monitoring systems, but it also could be, CIP systems and any systems that you use. What are the inputs into your systems? Was there a decision made, 10 years ago to exclude a certain class of customers or a certain class of accounts into that system? And has it been revisited? And are you sure that you don't need that group of customers or that group of accounts coming into your system now as a feed or type of transaction? Second thing, once it's in your system, what about your parameters? When's the last, when were they set? Again, were they set 10 years ago and have they not been revisited since? Has your risk profile changed since 10 years? Yes. I think there's probably no financial institution around that hasn't had at least some changes in their risk profile. So when have those parameters been revisited? Are they at an appropriate level? Are you getting way too many false positives? Are you getting way too many false negatives? And how are you dealing with that? I know that's a real challenge for firms. And finally, your outputs. When we go in to examine firms for AML compliance, one of the things we'll do is we'll ask you, we'll ask you for your alerts, and then we'll pick some accounts. And we'll often pick, what we consider to be some of the highest risk accounts, and we'll look at what alerts they triggered. And so if your system is supposed to be picking up on something and it's not, we'll find that generally. So, are the outputs of your system what they should be? Are you testing that on a regular basis? And are you getting the results that you want? I'll also mention one other priority, which is delegation. Obviously, AML is just one of those things where you really have to rely, the AML department, the AML officer cannot do it by themselves, right? There's real reliance on so many aspects of a financial institution, operations, new accounts, for securities firms, trade surveillance, et cetera. And what we find when we go in and examine firms sometimes is that the AML department will say, oh yes, we've delegated or relying on this other department to do X, Y, Z. And then we go to talk to that other department, they say, oh, no, we're not doing that, or no, that's not something we do. So, to the extent that there is reliance or delegation on some other business area or other area within the organization, do those people know that they know what they're supposed to be doing? Is it codified in some type of policies and procedures? Have you trained them, right? Do they definitely know what they're supposed to be doing, and are they aware of it? And finally, are you doing some type of testing or checking or meetings or something to make sure that everybody still has a common understanding of what those delegated responsibilities are? I will say, just on the FIFIC manual that, or on the FFIEC manual, that we don't publish our exam manual, but I will tell you that the SEC and FINRA both work together to establish common examination basically procedures, so that if you get examined by the SEC or FINRA, you will see a common questions and such.
Okay. Christine, you mentioned in your opening comments the new law in place, the new laws and regs, whatever. So that obviously must be a priority for you. But in addition to that, you also talked about the lines of defense. Mm-hmm. Given what Sarah said, are those some of the same things that you guys look for? So sort of you go in an institution and whose responsibility is what? And at a minimum, there needs to be enterprise-wide awareness of their roles. And probably that's something that you see as a challenge or what?
Yeah, I mean, everything on this panel, it's interesting because you almost not put a Canadian or U.S. label on it, and that the themes are very, very similar. So when we go into an institution, we look top down and bottom up. So we are going to look at the Chief Anti-Money Laundering Officer's mandate, and we're going to look at how that is in practice being applied across the organization. If it involves delegation, so you have a decentralized model, we're going to look down into those lines of business, and we are going to test, to Sarah's point, do people understand their roles and responsibilities? Is it being executed? Which is why the second line of defense testing for us is such an important component of a successful and proactive AML program, because we've seen in many institutions where there's an assumption by the corporate AML group that certain components of the program is being done by various areas in the organization. The regulator shows up only to discover, in fact, it is not, or there's some confusion as to roles and responsibilities. So we feel it's very integral to the success, and so we do focus on that independent testing, including the second line of defense. I also want to mention from a priority perspective, I did mention the 2016 regulatory package that came into force in June, but you know, as they say, there's never a dull moment in the AML space. So our Department of Finance is currently working on a second tranche of regulatory amendments, and they are looking to pre-publication targeted for next year, and they will be strengthening some of the CDD, things like simplified CDD for low-risk entities, CDD and record keeping for prepaid products, virtual currencies will have requirements similar to MSBs, and foreign MSBs that provide services to Canadians will be captured under the legislation. So we'll be engaged in consultation with industry and the Department of Finance, and as well there is a parliamentary review that's going to be starting in 2017. It's and again, we'll be providing input into that. So, you know, we have the policy side of new regulatory amendments. They'll keep us busy. And then with our assessment work, things like the quality of controls, we do focus on higher risk clients and inherently higher risk businesses. We feel that, you know, the whole purpose of, you know, is to detect and deter, and arguably it is the higher risk clients and entities where there is perhaps an easier road for money laundering and terrorist financing. So for us, you know, the rubber hits the road, so to speak, when we test files pertaining to high risk clients and businesses to see the application. You know, are they rating these clients higher risk? Is it consistent? And then as well, are there special measures, enhanced due diligence, or some of the due diligence efforts really looking like standard due diligence? And, you know, that's a common theme where the inconsistency of application of enhanced due diligence for higher risk customers tends to pop out once you start to drill down into file samples, which we do. And that'll be a consistent theme in the work that we do. We feel that a true assessment is through the client testing of these higher risk areas.
I'm going to come back to the high risk in a couple of minutes. You had a point you wanted to make, then I want to go to Rick. Thank
you very much. I got so involved in my discussion of CDD that I didn't mention any other agency priorities, so I apologize for that. We are laser focused on risk-based examinations, and I think everybody on this panel is, but I think it's very important. Someone mentioned burden. It might have been Andrea. That is such a key issue, burden on the banks. We're really engaged in making sure that we have our exams very much focused on risk. I think everybody in the room probably also knows that the OCC has really tried to be a thought leader, both domestically and internationally, with regard to fintech. That's something that we're continuing. It's an important initiative for us. We have the Office of Innovation that stood up in December of 2016, and they are moving forward really very, very quickly with meeting with firms and so forth. So I think that's a great thing. We're also very much in tune with the problems around financial inclusion. We published our paper in October of last year for foreign correspondent banks. That bulletin that came out in October of 16 has a piece in it regarding consideration of financial inclusion, consideration of the needs of the client and of the clients that they serve or the customers that they serve. So that's very important to us as well. We're also very much in tune, and we hear the industry speaking at every event we go to, that there is a need for clarification around model risk management guidance that the agencies, the Fed and the OCC put out in 2011. As you may know, some of you who have been examined by the OCC, we have been applying that in a risk-based manner, the model risk management guidance in the AML space. You have a lot of questions about that, and so we really are working hard to try and find a way to answer those questions at this point. So, thank you.
Sorry, John.
Go ahead, Christine. Sure.
To Spencer's point about model risk management, I also want to mention that as another priority, areas such as fintech, cyber, and AML models, we are starting to, I guess, improve our working relationships with our specialist areas within OSFI, recognizing that we cannot be subject matter experts on everything such as cyber, such as the technical expertise required for AML models. So we are focusing on leveraging on the expertise within our own organization. We have divisions that their priority is cyber risk, their priority is fintech, and their priority is model validation generally at banks. So working with these groups to leverage off of their expertise and bring that into the AML work that we do. One area in particular is AML model validation, which, the Canadian focus has been different than the U.S. in terms of expectations, but it is an area that we are starting to work with our internal model partners on to try to enhance that aspect of the work we do.
I just put up a slide that you have in your materials that Andrea shared with us. It's just SAR data from the past couple of years. Just want to make sure you knew that was in there, and obviously all the other information is available on FinCEN's website, the SAR activity review, the SAR trends, and all of that, but just a good snapshot.
And actually, if I could just add to that.
Yeah, sure, go ahead.
One of the things that you could do that we keep updated is you could actually go onto our website, and we have SAR stats. You can go in there and you could plug in any kind of information that you want to extract to get the stats about. So if you are a depository institution and you want to know how many files have been filed by depository institutions in this jurisdiction that involved this type of issue, you can plug all that in and then generate the results of that. So this is just an overview of, sort of all SARs and a breakdown of, the percentages of coming to which sector of the financial industry has filed what. But it is a really, really great tool. I actually use it all the time. And you could see sort of what are the most common filings that have been, issues that have been filed about, so, or, all those kinds of things, jurisdictionally based, by year, by month. So I encourage you, if you're interested in that, to go take a look at it.
It's great at parties too, right?
Yeah.
So we have another question that I want to ask Rick a couple of things. We talk about senior management involvement, tone, all of that. So the question for you is, my financial institutions or clients corporate culture is much improved, staying the same as last year, needs work, or I'm actually worried. So take some time and give us your responses. And you know, we've been doing this at all the major conferences, and the data's pretty good because I think a couple of years ago, it was almost 50-50, people that were concerned versus felt pretty strong, and then it's gotten a tad bit better. I mean, obviously we've had the corporate culture guidance document from a few years ago, and all the agencies obviously look at that very carefully. Rick, what I wanted to ask you is, you've been at BB&T for a bit, and you're obviously building your program, you're adding people. From a regulatory standpoint, high level, what's the biggest challenge for you as you build out? And I guess what I'm looking for is, you clearly have some support, you have a lot of support at the highest levels, but also you're building out, you're adding staff, obviously you must be dealing with third parties. So if you're giving advice to somebody who's coming into a new situation and has to build, has to improve, from a regulatory challenge issue, what are the biggest issues for you?
So I'm actually first going to go back to something Spencer said, because I thought it was really important about cost containment rather than a cost center. That is a great message. Spencer and the rest of my colleagues, I would love for you all to be telling the CEOs of institutions that that's the issue. I've been very lucky at BB&T because senior management all the way through the CEO and the board of directors are very well aware of what it is we need to do to have an effective AML program. So I don't want to say cost hasn't been a challenge, because it's a challenge everywhere, but I came in with a plan, which I think you need to do when you want to either enhance or retool or make changes, and got some good cost estimates on what it was we were going to need to do, what kind of staffing I thought I was going to need, and got approval through senior management and commitment before I began to move forward. So that is always a challenge, though, and I think in an environment that we're in now, where costs are being looked at, a message from our regulatory colleagues to the leadership at institutions about this would be wonderful. So that's one challenge. I think the other challenge, and it continues to be a challenge, and I know that I whine about it, so I don't want to sound like I'm whining, but with multiple regulators, we still have multiple expectations. And that continues to be a challenge. I don't know that it will ever go away. We try and balance that, but we do have examiners that have different perspectives from the different agencies, and you can't always point back to the FFIC exam manual and say, well, this is what the manual says, because the responses you get is, we understand your institution and we think your risk is here, we think your risk is there, or discussions around that. So, and it's not unique to where I am now. I have, since I left the government, and folks when I was in the government used to bring that to my attention, and I tried to address it while I was there, but I think it will always be a challenge. And it would be wonderful to get everybody in the room and understand what all those expectations are for all of the agencies, especially if you have multiple supervisors. I don't know that that's ever going to happen, but to me that is a significant challenge.
The question about risk, Christine talked about the management of high risk, and this is going to seem like a facetious question, but it's not. Do you folks believe that banks can actively manage high-risk customers? And the reason I ask that is because as you look at inclusion and access, some of the response of the regulated is, we believe we can, we don't think our regulators believe we can, so we're going to take the easy way out and perhaps exit or not on board. Fair or unfair, that's something we continue to hear. So Suzanne, the general question, which again, I know the answer will be yes, but, so the general question, can banks, in your view, manage high-risk customers?
Some banks can, yes, not all. And I think the important part is to be clear and to have clearly delineated policies and procedures. And again, I would encourage you to look at other areas of risk within your institution and think about what you've done as an organization. So credit risk, of course, comes to mind. We have decades of dealing with that. What are the factors that your firm is considering or is trying to measure in making those risk determinations? And this is an issue that's going to get more emphasis now because of the requirement within the CDD rule to have a customer risk profile. I think in general most banks have that, or rating, risk profile, but it's a specific element. So I think we're going to see a lot more focus on that, and banks need to be able to support the risk factors and how they're applying them and how that translates to their customer base. But as we mentioned in developing our guidance, and the manual in general, we're looking at industry comments and we're having outreach meetings. And, as part of that, I did actually read through the Way Forward document the ACAMS put together. And there was actually one statement in there that I wanted to address because I feel that it's something that there's a misunderstanding. So there was a statement, I think it's on the top of the second page, that says, what became clear throughout this dialogue is that some FIs or financial institutions are already being told by examiners to go below 25%, a position contrary to all public comments on this rule from the government.
So before you answer.
Yes.
Absolutely what came up in those meetings, no question that many examiners have said, we know what the reg says, but because of risk, you're going down lower. So just so you know, that came with 100 banks. I'd say half of them said they'd at least have conversations about it, not necessarily that they made their changes, but go ahead.
And the reason that I want to address that is because I'm sure that examiners have, and that is okay. Because there are two aspects. I'm probably going to create a triggering event for Rick right now. But
it's already there. So go to it.
See your shoulders.
Go to it.
There are two elements of beneficial ownership. There is the technical aspect of the 25%, which is going to have its main impact for your legal entity customers that are low risk. And then there's what you do of beneficial ownership as one of the four components of the CDD program rule. And keep in mind, as I mentioned before, you already have a risk-based approach under CIP for when you look through your legal entity customers and collect information. So if as part of that, as many banks have, you have decided, for instance, maybe it's private banking, maybe it's some other type of customer, to collect at a 10% threshold. Again, there is nothing in the new rule that means you should stop doing that. And I know that was a specific example that was mentioned in the dialogue. And another thing to consider, in addition to the percentage, is that there are many exclusions and exemptions in the CDD rule. It's actually almost over 2 pages. We're putting it in an appendix in the manual. So, for instance, there are customer types, trusts being one of them, that are excluded or exempted, I can't remember which, from the definition of legal entity for the beneficial ownership rule. However, I would be surprised if already you don't collect some beneficial ownership information on certain types of trusts that you put in a higher risk category. So that's why I feel this point is really important. And again, in terms of all public comments to the rule from the government, if you look through, I'm not saying, it's something we do for fun in Washington, but the preamble to the Federal Register notice to the final rule has many statements, like I said before, in addition to this very specific point on the 25% and whether you need to get to a natural person for certain types of ownership. So I just want to make sure, because I know everybody's going to be talking about the CDD rule, that we address that misconception.
Rick?
So I think, Suzanne, I think that's a real problem because there is a lot of commentary in the preamble that talks about 25% is the right place to be, and that studies and commentary that we've seen elsewhere from government when we've been at conferences like this talk about after a lot of discussion, that's where it came out at the 25%. It sounds to me like now we're thinking about bootstrapping in from other provisions that say, well, if you have higher risk, you should go lower. That's, and maybe I'm not reading it correctly, but that, I never read that from the rule. I read from the rule that it said that you might want to go lower. 25% is not a mandatory, but I don't remember reading where it said that if you have higher risk, you should be thinking about going lower. And I think this is going to create a significant challenge for the industry in terms of saying, well, we're not only going to look at the rule now, we're going to look at other things that you should be thinking about in your whole risk management process, and then we're going to challenge you, and there's no clear definition about how that challenge is going to come on what is below, what you should be thinking about below 25%. Because I would tell you that I might have very high-risk customers, and I don't see any reason to go below 25% at all. I might see others where I might say, you know, I think maybe because we filed a suspicious activity report as part of some enhanced due diligence, I'm going to drill down below 25% now that I've identified some behavior. But I think this throws out a huge quagmire as to everybody that's already looking at what to do with their program, and a lot of us, including myself, have been saying, I'm sticking at 25%. I don't see any reason to go lower, and I think that works on my risk management process. Now I'm thinking, well, the first thing that's going to happen the first time I get examined on this is I'm going to be challenged about why I didn't go below 10%. So below 25%. If that's what you all are thinking about, I think some clarity on FAQs needs to be right away, because I would say that, at least from our discussions in Washington, and I think we'll hear it tomorrow when we do these roundtables, there are a vast majority of organizations that have already decided where they're going to put that threshold.
So, and just one point, but obviously it's Vincent's rule. So what I was specifically referring to is banks already have a risk, or should have a risk-based approach for when they're going to gather the beneficial ownership information or look through certain types of legal entity customers. And there was at least an implication in some of the comments that there would be a rolling back, that you had already 5 years ago decided that for certain types of customers, the bank collect at 10% level or something, and that, you know, that it would all be rolled back to 25. If your institution has decided, or has already decided that collecting at a 25% ownership threshold is appropriate given the risk of the customer, and it's the same for low and high risk within your portfolio, then that's the decision. But there was never intended to be a rolling back of the supervisor expectation, or there's no change in the CIP requirement.
So I know you want to make a comment, and I apologize, but I don't think that anybody ever said we were going to roll back. I think there was a discussion about what the collective industry was thinking about, and we have now guidance from a rule about what to do with that. So I agree with you. If an organization has said up until May of 2018, I'm at 10%, and now because there's a rule out that becomes effective in May of 2018, I'm going to push to 25%, I think that needs to be a discussion. I don't recall anybody saying that when we had our day session in Washington, and I think that would be a silly approach. On the other hand, the comments that were being made were examiners were coming into institutions asking about what institutions were thinking about implementation, and when an institution said, I think I'm going to put it here, examiners were saying, no, that's not going to work for you, you need to think about going lower. And again, to your point, if it is a FinCEN rule, I think we should be taking guidance from the rule unless the rule is going to change a bit.
All right, we got a few minutes. I probably should have done the whole session on this, but Andrea, I'll go to you, and then I do want to ask you guys one more broad question before we finish.
Yeah, I mean, I think that 25% was intended. That is an international standard. There were a lot of factors that went in. It could have been higher, it could have been lower, and that is sort of like the starting point, 25%, but that doesn't mean that you should, and I don't think the two of you are so far apart in what you're saying, frankly. I think you do have to look at what ought to be the appropriate percentage for the risk that you are facing. If an examiner is saying it should be something different, I mean, that's, why are they saying it? Is that appropriate for them to be saying it? That's a different question. But as an institution, you have to make a determination is 25% is a starting point. And maybe that's absolutely the right one to go, and that's where you should be. And that's a determination you're going to have to make. But you have to make the determination, right? For depending upon what the risk is. So I think that, I don't think that you're actually all that much apart in terms of what we're thinking about.
Spencer.
All right. So the question you asked originally that led to all this was, can a bank provide services to a high-risk customer?
Right.
I'll go back to that. I'll stay out of the CDD discussion.
I should give you credit, too.
I said yes.
This is Spencer's takeaway, which he talked about earlier, so I'm leaving that up. But go ahead.
So the high-risk customer question. The answer from OCC's perspective is certainly yes. They can bank high-risk customers. All they need to do is make sure they have in place appropriate controls to manage or mitigate that risk. I think what's important about that is, how do you do that? In my view, you have in place the appropriate staff and a BSA officer that can manage that risk, to help the bank manage that risk. That goes back to the question prior to that John asked, and that was about culture. A bank must place, and I've said this before, I think I said it last year here, the appropriate stature and influence on the BSA officer for them to be able to effectively help the bank manage through the risks. And so if a BSA officer is being propped up, is being recognized as having proper stature and influence, I think they have the ability to help them bank higher risk customers without any issues.
Great. I have one more polling question. It's a little off topic, but I thought it would be interesting, and I'm sure the vendors would appreciate you responding to this. My financial institution's current automated suspicious activity monitoring system was first installed less than a year ago, more than a year ago, but less than 5, more than 5, less than 10, more than 10, or what monitoring system? So I'll leave that up. Here's my last question. We talked about financial inclusion. There's sessions at the conference on human trafficking. There's been talk in the financial sector for a number of years on trying to get credit for doing things that advance societal goals. That's not why bankers put together anti-human trafficking programs. That's not why they bank NPOs. But what they say is, with the cost and the uncertainty in some cases, it would really, really help if there was some benefit. They didn't say necessarily financial or safe harbor or whatever. And I know you can't speak for your agencies, obviously. But let me just throw that out. Is there any possibility from all your years of experience that we could come up with a way, you do it in the CRA world in the U.S., right? Community Reinvestment Act, you get credits for loans in certain areas. Is this an area that's even possible? The reason I mention it, and Christine, I'm not excluding you, but in the U.S. there's actually been talk of some possible congressional interest in this, and so there may be actually at some point legislation. I'm not naive to suggest it could move, but just that general concept. Is it fair to say that the financial sector is looking for some credit, and is it remotely possible? Suzanne, I'll start with you and then go to Christine.
Sure. So yeah, this is an issue that's come up, and I understand the frustration because, what we hear anecdotally from law enforcement is some of the most useful SARS, the best work, is a result of work that banks are doing almost on a voluntary basis, that they're not technically required to do. Maybe it's a name that's been designated by OFAC, and they take that and throw that back against the database, identify other related parties, file a SAR that provides a lot of additional leads to law enforcement. So I think what we're really talking about is maybe some changes to the assessment of the adequacy of SAR monitoring or even the compliance program. Because, right now that's done by the supervisor. And what we're talking about is things and initiatives that are of benefit to law enforcement, which is, of course, the whole purpose. So I think it would maybe take some sort of more formalized way to integrate that input from law enforcement agencies into that assessment of the adequacy of a financial institution system, which isn't sort of established in that way right now.
Right.
I think that's what would be probably useful.
Yeah, absolutely. Christine?
So this issue has come up in Canada.
And I want to say something on that too.
Oh, sure. This
Go
issue has
ahead.
come up in Canada, I would say, more in the margins. In that, one of the questions with respect to the societal goals is, do institutions perhaps inadvertently take on the role of law enforcement? And are resources being spent at a institutional cost to further the goals of agencies, law enforcement, that may not have the resources to meet all of their priorities, and then there's an expectation by government partners that the institutions may do more and more. And in that case, then I think it becomes a controls and governance issue within an organization to ensure that they may not have resources who, out of personal interest, are taking it into the law enforcement realm. So I think there's that one aspect of it. How far should you go as an organization before you are starting to go beyond the obligations and expectations? The other is just the general societal value. And a conversation that I had with a CRO at a large institution who sort of questioned the bank's role in this regard was, looking at AML in the same lens as the bank looks at being a good corporate citizen, and that banks sponsor many events such as hockey tournaments and United Way campaigns and other social issues. And how is something like human trafficking or whatever it is that comes out of the work in the AML space, how is that any different? And I just think historically the lens has not thought of it as a societal issue, which goes to increasing the education in an organization to show not just the cost or the perceived cost, but also the benefit to society when you're sitting on a house of data that through extraction and specialization can actually put some benefit into society through that linkage to law enforcement through the reporting.
You got time for a quick comment, Andrew?
Yeah, I think the answer is yes. There must be some way to be able to integrate acknowledgement of the work that financial institutions are doing to assist law enforcement above and beyond what they're, above and beyond what they're obligated to do. I will tell you, I know that this is just sort of a starter thing, but going and we have law enforcement awards which specifically detail the role of SAR data, and we send letters to financial institutions to recognize what that is. I think, combined with the getting credit is, can we do less of this and only do that? And I think that's going to be a challenge, because all of this is important, but the question is, how can we shift resources, help financial institutions shift resources to sort of the higher priority, and then acknowledge in the way that they do that. But, I think it is something that we have to really think about and look to do.
So perhaps somebody could write something up for ACAMS today and do some research on this, because the reason for AML, no offense to our panelists, is not to do regulatory response. It's to get information in the hands of law enforcement. And sometimes I think we get away from that. So I think that's important to recognize. I want to really thank the regulators and Rick for participating, Spencer, Sarah, Christine, Andrea, and Suzanne.